Opening day for the U.S. Supreme Court is October 5th. As the High Court kicks off its 2015 term, criminal law cases dominate the docket. From the death penalty to juvenile sentencing, Vincent and Elkin's John Elwood breaks down some of the criminal issues before the justices this term. So 20% of the cases that the Supreme Court decided last year were criminal law cases, but this year about a third of the cases that the court has already agreed to hear are criminal law cases. Do you think that the justices are more focused on criminal law issues this term, or do you think that the grant level is going to even out?
I think that that's just kind of what happens whenever you have kind of small numbers. The court only takes 70 to 80 cases a term. And so it's really not, it doesn't take much in order to get elevated levels of any type of case. I mean, in this case, the difference between 20% and a third at this time of year is really only about 4 or 5 cases. And so I think it's just kind of noise that they just happen to get a few more cases that were criminal that struck their fancy early on. I noticed that a lot of them are capital cases, and they, you know, when a case is credible, a credible capital case, they're much more likely to grant. And I think that accounts for a lot of it.
Well, tell us a little bit about those death penalty cases. Of course, death penalty was at the center of one of the most contentious issues or cases last term, Glossop versus Gross. How will the Supreme Court deal with death penalty this term, and how do you think the justices will come out?
Well, one thing, you know, it appears that Justice Breyer and Justice Ginsburg are not going to be voting to uphold any death penalty from here on out. And one thing right off the bat, it means that the states that bring capital cases to the court or are respondents in capital cases in the court are going to have to count to 5 without them. And I don't know how many cases, I haven't gone back and looked to see how many death penalties those two justices have affirmed. But I have to imagine, I mean, especially Justice Breyer is something of a swing justice on the left. And having him be essentially unavailable is going to affect the decision-making of states that find themselves in that position. And when you consider that the first sitting has, you know, essentially a day and a half of Eighth Amendment arguments, it's going to have an entirely different feel than if it had been done 1 year earlier. Because right off the bat, you know that, you know, Justice Breyer and Justice Ginsburg are not really available votes. And if you think about, I mean, presumably it was a very deliberate decision for Justices Kagan and Sotomayor not to sign on to that. But you know, you really don't have to lose that many additional justices before it really becomes very hard to get capital sentences affirmed on appeal. Which is one thing that I think is interesting is Justice Scalia said recently in a public appearance that he didn't think it was beyond the pale, or he said he could see his colleagues voting to essentially invalidate capital punishment. And admittedly, he's a little bit like, you know, the cat that sat on the hot stove after the same-sex marriage cases. So he might be, you know, extra vigilant and exaggerating the risk of them doing certain things. But, you know, someone who knows the court very well thinks that that's a realistic possibility. Can
you tell us about some of the other cases? We've talked about death penalty, but there are also a number of other criminal cases. What do you have your eye out for?
Montgomery versus Louisiana is a case involving the retroactivity of the Miller case about sentencing juveniles to life without possibility of parole. And I don't think that's, you know, that important a case in terms of doctrine, just because the retroactivity law is fairly settled, but it's important just as a matter, it's important as a practical matter, as demonstrated by, you know, Mr. Montgomery's case. You know, he was sentenced as a juvenile, he's now 69, and there are plenty of people in prisons who are in the same situation and who might find themselves released from jail early if the court finds it as retroactive.
Well, we've been talking a lot about death penalty cases, and there are certainly a lot of death penalty cases in the court's first sitting, but there's still a lot of room for other cases this term. What are you keeping your eye on? What's in the pipeline?
One thing that's noteworthy is the court doesn't have any Fourth Amendment cases, and the court's docket, criminal docket, is heavily composed of procedural issues and very heavily composed of Fourth Amendment issues. And one Fourth Amendment issue that I definitely see coming down the pike is whether cell location information is subject to search warrants. That is, before you can get information about, you know, basically cell phones that were in the area of a cell tower, whether that requires a warrant or not. The Fifth and 11th Circuits have held it doesn't because that's information that people are voluntarily exposing to third parties under third-party doctrine, the same reason why you don't need a warrant to basically get telephone information. And the the Fourth Circuit has held that you do need a warrant. And although I believe the government's time for rehearing hasn't passed, and so there's still some chance that the Fourth Circuit could bring its law into line with the Fifth and 11th Circuits, it's out there now. And the Third Circuit has also said things which suggest that a warrant isn't needed. So I think that issue is definitely going to come to the court within either this term or next. But I think it's inevitable that it will come. And when it comes, both the court's decision in Riley versus California, the cell phone search case from a couple terms ago, and United States versus Jones, which was the GPS tracking case, and Justice Sotomayor's separate opinion in that case suggests that the court really is primed to say that it's going to apply traditional Fourth Amendment doctrines in a different way when it comes to digital age evidence.
Well, we'll certainly keep our eye out for that issue, and thank you for breaking down the cases in front of the Supreme Court this term. We'll be following those cases on Bloomberg BNA's U.S. Law Week and Criminal Law Reporter.